Ready, start. Serious objection was raised regarding the said impugned FIR registered at that police station, which did not have any jurisdiction, which FIR was claimed to have been transferred to the jurisdictional police station, that is, Electronic City Traffic Police Station, after 117 days. If the FIR is registered on the basis of the accident or on the detection of the abandoned body, then it should have been registered in a police station having jurisdiction over either of the two locations. In the present case, PW1 had categorically stated that she was informed of the accident by PW2, in which event the location was clearly known to PW1 and the FIR are to have been registered at the Electronic City Traffic Police Station itself in the first instance. There is no explanation as to why the FIR was registered in the Hebogodi police station, nor was any police personnel examined before the tribunal to substantiate the case of a proper FIR alleging a motor vehicle accident having been registered within time and with the jurisdictional police station. It is on preponderance of probabilities that the proof of accident is looked at in a motor accidents claim. An FIR registered as against the driver of the offending vehicle can be relied on to find the accident having been caused by the driver of the offending vehicle, that too by his rash and negligent driving as reported at the first instance. However, the preponderance of probabilities that arise from such an FIR registered would not have the same probability if there is a valid suspicion raised on the registration of the FIR and the falsity of the claim being clearly discernible from the evidence led itself. As has been rightly found by the High Court, the testimony of PW2 is unbelievable. PW2 deposed that she was running a wayside fruit shop near the scene of occurrence, which has not been established by any document like the license issued from the local authority, in which event she is deemed to be a chance witness subject to strict scrutiny. Further, her testimony is that, having witnessed the accident, she came running and saw that her neighbor was the victim. She immediately realized that the victim's daughter was studying in a nearby school, to which school she proceeded to bring the daughter, who was studying in the 7th standard, to the spot. By the time she came back with the daughter, she deposed in her chief examination the vehicle had disappeared and so had the victim. However, she also stated in chief examination that the number of the vehicle was noted by herself and the daughter of the victim. The said statement is quite contrary to the assertion that by the time PW2 came back with the daughter, the offending vehicle and the victim had disappeared. The daughter of the victim was also not examined. The High Court had listed out the reasons to reject the application from within bracket A to within bracket F in paragraph 8 of its judgment.